Michael Grenfell. Welcome to Digital Markets Research Hub. You are an established authority in the area of UK competition law, obviously EU competition law, because we are sister regimes for many years and for obvious reasons. And your vision matters a lot. So I wanted to learn in this conversation about your understanding of quite a few processes, mainly focusing on digital markets, but maybe we can have a chance to look at other issues, maybe broader first order issues, or maybe some more technical things as well. But as a starting point, allow me please to ask you maybe to remind to the listeners and viewers the key milestones of your professional career, your background.
Okay, well, thank you, Olis. Thank you for having me on, and I'm delighted to have this conversation. Uh, my career has basically been that of a competition lawyer in London, like many other competition lawyers. It's been a very enjoyable, very interesting career. I was a lawyer in private practice, a partner at one of the big city law firms, and now I have just gone back into private practice and I'm a partner at Clifford Chance. But I was very fortunate to have two lucky breaks working in the um, in the public authorities that enforce and create competition law. So when I was an associate, quite junior, I was seconded for 18 months to the government, to the what was then called the Department of Trade and Industries, now the Department for Business and Trade, where I had the responsibility for competition policy on an international and EU level. And then the last 10 years up to this year, I have been at the Competition and Markets Authority, the main UK competition agency, where I first worked on sector regulation and competition. And then for the last 8 years, I was a member of the CMA board and I had overall responsibility for the enforcement of competition laws, the prohibitions on anti-competitive practices and abuse of a dominant position, and also consumer protection laws. And now, at the end of that very fulfilling 10 years, I've gone back into private practice. So a fairly standard competition lawyer's career, but with the benefit, which I think has been valuable, of some stints in the public authorities. And I would say, I mean, that I'd like to think that that helps me as a legal advisor, not because it gives you contacts within the authorities, not because it gives you the inside track on confidential information, but more because you get an understanding of how the authorities think, what matters to them, how best to engage with them, and perhaps most importantly, the policy context in which competition decisions are made.
This is precisely the information which those of us who didn't have an opportunity to absorb the institutional culture, the institutional conventions, we often miss this information because our either very academically oriented, very systematic, excessively systematic perception of this area of public policy, or on the contrary, maybe too particularistic if we are focused on this, or as practitioners on specific area, prevent us from something is missing in this jigsaw puzzle constellation. So I'm grateful for this opportunity, and maybe we can start with you highlighting your reading, your understanding of the evolution of UK competition policy, obviously in the farwater of EU, but obviously now also beyond. What are the key elements and the key periods of its evolution from your subjective but yet comprehensive perspective?
So I think I'd say two things really. One is that competition policy has become much stronger, much tougher, much more pervasive than it was when I began my career some 35 years ago, but also that it's become more important for businesses. So if we take each of those points, I think you will know that apart from what was then called European Community Law, then became EU law, Britain domestically had a very, very weak regime as late as the end of the millennium for enforcing against anti-competitive practices. It had something called the Restrictive Trade Practices Act, which was very, very legalistic, formalistic, and not very good at catching and still less penalizing the most serious anti-competitive behavior. That was replaced in 2000 by a much, much tougher EU replica regime with fines and so on. So that's one way in which it's become more pervasive. The other is that when it comes to looking at mergers, the UK domestic regime wasn't initially focused so much on competition. It looked at broader public interest issues such as research and development, job creation, a regional balance all across the country, and so on. And the much more precise focus on competition came first informally in the mid 1980s and then formally entrenched in the Enterprise Act in the early 2000s. And then, of course, the courts have got more powerful as an alternative way of enforcing competition law. So it's all become much more powerful. And then because of that, I think it's become much higher up the agenda of business leaders, of corporate chief executives and boards and so on. So that, again, when I started, it seemed like a highly technical, slightly esoteric bit of the law, not likely to trouble you, except perhaps when you were doing an M&A transaction. Now, I think, given the real risks in terms of fines, damages claims, reputational harm, adverse publicity, and so on, I think businesses are very, very well aware how important it is and are anxious to comply. And it's worth saying also that where businesses are victims of anti-competitive practices, either as customers from suppliers to business, or facing competitors and rivals who are not competing fairly, this gives them rights to challenge that, again, both in court and before the competition authorities. So I think it's become much stronger, more focused than it was when I started my career. And because of that, I think businesses have become much more aware both of the risks and the opportunities that it presents.
And among other issues which you have highlighted, important issues, emblematic issues, one
Yes.
is that competition policy is an inherently evolutionary process, essentially.
Yes.
One of maybe it's our luxuries that it's continuously self-discovering and showing new features which were either unknown or long forgotten, but it's evolving. And
Yes.
so my question is, there was a period in competition that the answers are discoverable in their entirety in economics, in neoclassical economics. It gave our curious minds some peace, and we somehow started focusing on technicalities. Now we are the pendulum or the cycle, whatever, is shifting to much less certain, much less formulaic, much less axiomatic, and thus one of the implications it appears from purely logical observation is that the desire to autonomize, to distant competition of enforcers from broader societal public policy considerations is less underpinned by this by the current circumstances, because in the past any broader societal influence could be portrayed easily and perceived as noise, preventing us from our nuanced calculus. Whereas nowadays, once we stop relying exclusively on the calculus as mantra, in absolutely correct formulas, should we recalibrate or start rethinking our relationship with broader public policy agenda? And if yes, is it doable or it's toxic per se?
So I mean, I think these are very, very good and thoughtful points. I mean, I think a couple of so first of all, I think you are absolutely right when you say that it's constantly evolving. That of course makes it more interesting, also more challenging, but it means that that it is, as you put it, an evolutionary self-discovery, and that must be a healthy thing. I guess, if you look at the last 10, 15 years, there have been two trends. One, the balance between a very legal focus, and the other and between a very legal focus on the one hand and more economic concerns on the other. And that's a constant balance and a constant tension in competition policy, competition enforcement, competition compliance, because the advantage of it being more economics based is that decisions and analysis and so on more accurately reflect the real world truth of what's going on. The disadvantage is that there is less certainty, and a more legal approach gives a degree of certainty of understanding which makes life more predictable for businesses and for authorities. And it seems to me you can't go too far in either direction, and there needs to be a balance, and that's a constant tension. And that's something that has evolved quite a bit in the last few years. At one point, the European Commission, particularly in some of its analysis on vertical restraints and on exclusionary abuses, was very, very much focused just on economic harm. But then there's a realization where you do need a degree of predictability and certainty for businesses to be able to operate effectively. So there's that balance. But then there is the point you make about wider societal considerations. And I said, I think when we were talking the previous question, I said that, in the UK, there'd been a broad public interest test, and then in the mid 80s and even more from the 2000s onwards, there was more of a competition focus in merger control, in market investigations and market studies and so on. There has been a bit of a backlash against that, as we all know. At its most radical, it's identified with that American academic trend that people call hipster antitrust, which is a realization that that an excessive focus on competition without consideration of impacts on employment rights and the way people live, on possibly on the vulnerable and so on, is too narrow and actually risks giving competition law a bad name, because it looks like it's pursuing something that's very, very technical and completely indifferent to the wider world. And the danger is the public will say, well, if competition is saying this, and we all think that there are these problems which pursuing competition is not addressing and maybe even making worse, such as possibly inequalities and so on, then unless competition isn't to lose its legitimacy, some attention needs to be paid to that. Now, of course, there is a danger in that, which is some of these judgments and trade-offs are highly political. And if public authorities who are unelected are making those judgments, there's a democratic issue and a democratic deficit. So, as I say, at the most radical with the hipster antitrust in academia, but obviously with the current US leadership in the antitrust division of the DOJ and in the FTC, there is more attention being paid to those wider societal concerns. And other competition authorities across the world, including in the UK, cannot but pay attention to those trends. But as I say, being careful that you're not having unelected institutions making big policy choices, and that's a difficult balance. And I think we're going to see that. How it'll be very interesting to see that how that plays out in the coming months and years.
To continue with this, one of the implications, or one of the features of this broader public policy consideration, that they're usually very vague, and they are interpretable in myriad of ways. So if this is a systemic trend that the CMA or on all other competition enforcers in other jurisdictions have to engage on a more continuous basis with, let's say, Department for Business and Trade as a publicly accountable and legitimate public authority, should this information be somehow manifested, declared, or it's something which is somehow in the institutional memory and it's impossible to verbalize and formalize? It's something which you sense more than you speak of.
So I don't think people make a secret of it. I mean, you can see it in the speeches of Lena Khan and Jonathan Cantor. You can see it in the speeches of the CMA leadership, of the leadership in DG Comp at the European Commission. More attention is being paid to other factors, but there's also a consciousness that there are limits to it along the lines we've just been talking about. So if you take something that the CMA and the European Commission and a lot of other competition authorities have got involved in, the nervousness that that an overly rigid adherence to competition law shouldn't stymie moves to improve environmental sustainability. And as you know, a number of authorities, the European Commission, the CMA, have issued guidelines on that. But note that they are all aware that there is the kind of balance we talked about to be done here. So note that outside those institutions, there were more radical voices saying, you know, you should take a very broad view of sustainability. You should take into account, you know, even wider societal concerns about poverty and the built environment and inequality and so on. And you should, in doing your analysis, you should weight it even more heavily against competition law. And note that although the guidance issued by all these authorities is a change from what went before, it doesn't go quite as far as some of the radicals were demanding, because quite properly of a consciousness about the dangers of the kind of democratic deficit. And one has to say, from the point of view of businesses, the more considerations come into analysis by the authorities, the less predictable it is, the less uncertain, and the harder it is to do business. So I think all competition authorities quite properly are paying attention to wider concerns, not wanting competition law to be irrelevant to normal life, but equally not wanting to act as substitute politicians who make wide policy issues, which, as I say, create questions of democratic legitimacy, and also from the business point of view, questions of predictability and certainty, and a danger of a certain arbitrariness. And by and large, I mean, it's a bit self-serving of me to say that because I was involved in some of these discussions at the CMA, and I think what it came out with on the environmental guidance was a pretty good outcome. They are alive to it. They're trying to balance it, and I think broadly getting the balance right. But it's a learning process, and it will be on other issues. Lots of competition authorities are now concerned about labour markets. You'll have noticed from speeches, and those similar considerations and similar balance arises there.
So with this in mind, let us move to the UK institutional
Right.
settings and look, or maybe ask you to offer similar X-course or return to the evolution of judicial elements in the UK institutional architecture. So Competition Appeal Tribunal, how do you position it in this constellation of antitrust enforcement?
Well, clearly it's become more important, and there are things that have. So, of course, it has a couple of roles. It's an appeal body against decisions under the UK and Competition Act decision, CMA, and regulators' decisions on whether there's a breach of the prohibition on anti-competitive agreements or the prohibition on abuse of dominance. So it's a sort of appeal body, but it's also a locus for bringing competition claims, private enforcement claims, including follow-on damages. And it's clearly become increasingly important and increasingly powerful. And I guess one would trace the two big milestones as first, back in 2004, when the EU had the modernisation regulation, the right of courts within the EU, as the UK then was, to make decisions on whether there's exemption or not. So it becomes more worthwhile to bring a case before the CAT or before other courts, because they don't just rule on whether there's a prima facie infringement of the prohibition on anti-competitive agreements, which you then say, yes, but then you have to go to the competition authority to see whether it's exempt. They rule on the whole thing, so it becomes more worthwhile to bring actions. The availability of follow-on damages after a decision by the competition authorities, another thing. And then most recently, making it easier for collective claims to be brought on behalf of hundreds, thousands of consumers, including the opt-out possibility. And we all know in the UK last year there was that foreign exchange judgment of the Court of Appeal that made that a degree simpler. You add to that the fact that the CMA says in its prioritization that one of the things the CMA will take into account whether or not to enforce a case is whether there are alternative means of recourse to businesses, and typically or to consumers. And obviously the CMA, like any competition authority, can't take on any case, so it's an alternative means of enforcement for those who have the means and the ability to do that. So I think it's a powerful and important bit of the competition landscape and complementary to the authorities, to the CMA and the regulators.
And maybe in this regard, the composition of CAT is quite peculiar. So it consists of different members with different pedigree. Obviously, is it an institutional specificity of the UK judiciary more generally, or it's something which has been extrapolated from other or transposed from other jurisdiction, or it's developed organically within the system? Is it something which has been Is it a problem at all, or it's absolutely accepted
So,
consensually as just a specificity? A and B, in this regard, so that we finish with Competition
yeah,
Appeal Tribunal. What is your reflection? How well predictable in this unpredictable world, rapidly changing world, the potential solution, the potential avenues for decision are in this interinstitutional relationship between CMA and Competition Appeal Tribunal, or
yeah,
it's every time it's a complete self-discovering, and
yeah.
you can somehow stop being surprised, and how much can be changed with one specific decision. Is it well settled, or it's kind of
So those are all incredibly good questions. I mean, the first thing to say, as you will know, if you go before the Competition Appeal Tribunal, the panel will often include someone with judicial experience, someone who's an economic specialist, someone who has been in private practice as a legal advisor, and I think, and it's a bit similar to the panel within the CMA that makes phase two mergers and markets decisions. It's an attempt to reflect the reality that we all know about competition practice, that it's not just black letter law, that you need to have regard to economics, to policy, to the real world of business. And I think it's an attempt to balance that. And obviously, I think the tribunal would be the first to say, like all these institutions, that they're learning along the way and refining it as they go. I think you are right to point to the danger of two key decision-making bodies going in, at least conceptually, could go in different directions, which makes life difficult for business. I mean, formally speaking, it's the judicial body that has the real precedent power, not the competition authority. But the reality is that there are attempts to make sure that divergence does not become too harmful for business. And you will have noticed an increasing trend on the CMA, which has the right to intervene as a sort of, like an amicus, as a third party intervener, to intervene in cases that raise issues of legal principle or policy, whether or not the CMA is actually looking at cases on similar facts or not. And that is an attempt to ensure that there is no great divergence. And again, it's an evolving thing, but the question that you raise is obviously taken seriously by both the tribunal and the CMA.
And the last question before moving to the Digital Market Competition
Okay.
and Consumers Act,
Yeah.
it's related to private enforcement. And
Yes.
namely, we see how rapidly it evolves, and we know the classical answer that it's win-win, and the more the better. But there is also another camp emerging saying that it can went too far, particularly when we design low-hanging fruit with open-ended catalog of obligations. Then it presupposes some selectivity and discretion of public enforcer, and it's kind of leniency effect. You can, if you open it to everybody, nobody will engage in the regulatory dialogue. And these are two extremes. I imagine there must be something. So is there any problem on kind of third
I
party
mean,
funded on steroid, or it's normal
what
evolution?
what what you are saying is absolutely right, and it's another of those tensions that exist in the practice of competition law and competition policy. And again, it's a matter of competing considerations. On the one hand, if there are victims of competition law infringements, which might be business victims or consumer victims, you don't want to make it so that they don't get any redress. On the other hand, you don't want businesses to be so extraordinarily exposed that, as you say, it becomes very difficult to reach some sort of negotiated arrangement with the competition authorities, whether it's under a leniency program or settlement or whatever. And also that there isn't a terrible chilling effect that you dare not do anything because the consequences are so, severe. And again, we can see that the law and the cat in its practices and its rules is trying to balance that. And there is a filtering process before a collective damages claim can be admitted, and there's a further filter on whether it should be opt out or opt in, and an attempt to ensure that sort of frivolous claims don't get traction. So that offers some protection to business and, frankly, some protection to the integrity and sanity of the regime and to the possibility of leniency programs working effectively. There is the same issue in the EU. It's the same, anywhere where there's both public and private enforcement. And, it's a work in progress. I think it's very important that courts and policymakers should be aware of the dilemma here, should be aware that, you don't want to paralyze business. You don't want to, absolutely right that there should be effective enforcement against the worst behavior, but you don't want it to have such a chilling effect that it's impossible to resolve issues and that the consequences are disproportionately severe. We haven't gone in Britain for the triple damages that they've gone for in the States, and all these are part of that balance. And it's difficult and it's ongoing, and it needs to be kept under constant review.
So now let us move to the Digital Markets Competition and Consumers Act. And what do you think about this? I'll have several questions. The first one is more general, and the most important question about the act. What's the right abbreviation, DMCC or DMCCA?
I don't have a view on that one, certainly. I tend to say DMCC Act, but then of course you have to be aware that not everyone you're talking about even knows that abbreviation. So sometimes one just has to talk about what the Act does. Look, what do I think of it is a big question. It's clearly a very important piece of legislation. It's the first major change to competition law for a decade, arguably for 2 decades. A lot of thought went into it, a lot of controversy about it, and as we all know, on the one hand, there were people who think that, as far as the digital markets element is concerned, that there is this huge new problem that requires tackling urgently and requires these special new powers. On the other hand, there were people who thought that there is a danger that some of the most innovative businesses in the world will be disproportionately inhibited, disincentivized from innovation. And that's a balance, and it's been very controversial. It's been controversial not just in the UK, but in all the other countries plus the EU, where similar legislation is being considered. And we mustn't forget, or implemented, and we mustn't forget that although the US hasn't instituted a regulatory regime like that, as we have seen in recent years, both the authorities and the courts have taken a much more activist antitrust approach to digital markets. So there's a controversy, there is a balance. It's one that's been faced in most countries in the world. I think the reality now is the Act is here. The digital markets regime is here. Whether we like it or not, or whether we think it goes too far, or some people think it doesn't go far enough, it is here. And the important thing for all those affected is to make sure that it works. And from the point of view of businesses, who may be in the focus of scrutiny, I think very, very important safeguard is that most measures, so the conduct regulations, the pro-competition interventions, the penalties, the remedies, have got to be proportionate and effective. And also, as we know, for remedies after as conduct requirements investigation, there is a possibility for an countervailing benefits exemption. Now, that's quite a lot for businesses to work with. And if deployed intelligently, it will and this is to everyone's benefit, not just the people under scrutiny, but complainants and the authorities. You will get a regulatory regime that, all being well, is proportionate, doesn't go further than necessary, and that the authorities, the CMA, will want to listen. They've talked about a collaborative and participative approach to make sure that what they've got is targeted and proportionate and doesn't overreach and overreaching mean have the negative disincentivizing effect on innovation that I don't think the legislators want, and I'm sure the CMA doesn't want. And so that emphasis on effectiveness and proportionality, the possibility of a countervailing benefit exemption, is the mechanism now, whatever one's view had been on the regime in the first place, for making sure it works effectively in everyone's interest. So that's one set of things. When we talk about the Act, everyone immediately focuses on the digital markets issue, but there are lots of other bits. There's some strengthening of competition policy enforcement. There's some cleaning up of the merger control regime, or changes to the merger control regime. But most significantly of all is the consumer protection measures. And many of the people watching this will know this, but just to be clear, until very recently, until now, consumer protection has been the poor cousin of public enforcement for the benefit of consumers compared to competition law. The CMA couldn't fine companies in breach, and indeed the CMA couldn't make decisions at all. They would have to go to the court to apply it for a decision. Now, what the legislation does is, I'm simplifying, but puts it on a par with the Competition Act prohibitions. The CMA can make a decision that there's an infringement. The CMA can fine businesses that are non-compliant. And when we were talking earlier, I think I made the point that in the course of my career, we've seen how competition law has gone from being something that corporates didn't really need to have much regard for, to being much tougher and very high on the risk agenda of all corporates, all CEOs, all company boards, and so on. Well, consumer protection, as it is now, is where competition was 20, 30, 40 years ago. And this change means it becomes, I would say, at least as much a risk for corporates as competition law is. The need to make sure that they are compliant, the need to make sure that they don't face these, what will be potentially swinging fines, up to 10% of global group turnover, becomes as urgent as competition law compliance. And that's about to happen. It's going to come into force in the next few months, and that's very important. Of course, it also means that for businesses who find that their competitors are cheating, there's a way of making sure there's a fair level playing field to make sure that they're not cheating. And I said at least as important, because one of the things that I noticed when I was at the CMA, but I suppose we all notice, is that many people, normal people you talk to when you go to parties or meet friends and so on, they find competition law sort of over technical and counterintuitive. But consumer protection law, someone's been ripped off and the business ought to be made to pay for it, people find intuitive. So I think the risk of fines is accompanied by a reputational risk that's at least as great. And so it is very, very much in the interests of businesses to ensure that they're compliant, just as they do with competition law. There will be lots of businesses who want to do the right thing, but that in some nook and cranny of their big business, some infringement is going on. And just as corporates like to do proper compliance and proper due diligence to make sure there isn't some competition infringement hidden away in the business, I think they'll want to do the same to make sure that they're fully compliant with consumer protection law, precisely because it's going to get so much tougher.
Without asking to look at the technical juristic details of this emergent still regime, speaking of these consumer protection matters, do you think, or what do you sense, maybe you again from the conversations and your personal observations, without asking for your juristic know-how, so to say, still,
Yeah,
do you think it's well fitted into the system overall enforcement mechanism designed by or existing and designed further, improved further by the act?
I think we're going to have to see how it pans out. I mean, one of the curiosities of consumer protection law, even more than competition law, is very often some of the disputes that consumers have with businesses emerge when they're buying things abroad, when they're booking hotels or car rentals and so on. Now, the fundamental law doesn't change that much. It's just the enforcement powers that have changed. As you will know, the CMA has in the past taken action against car rental companies, just to give an example. I don't want to focus just on that. So, there will be debate about the jurisdictional reach, and businesses would be well advised to keep an eye on that and make sure that there isn't overreach, and that will play out.
Also, we know that we all know that DMA is part of competition law mindset.
Yeah,
But it has been designed legislatively as a new start, so it's not competition law sensu stricto. It's something else, market integration measure. Whereas DMCCA is designed as a reform of competition law. Does it matter, or it's purely conceptual speculations, or there are some juristic implications?
I think it's I don't know the answer to that. I think it's an important question. As you know, the UK legislators who were very keen to emphasize that it is a pro-competition piece of regulation. It's not the kind of interventionist legislation of price controls, of of setting very prescriptive behavioral obligations on companies. I think, who knows how it will work out in practice. I think most people will observe that the EU version is a bit more prescriptive than the UK the new UK regime. And the UK regime has made a point of saying, in the first instance, it will try to be outcome focused rather than rule focused. And the thinking behind that, I think we know, is that digital markets evolve very quickly. You set a particular rule in place, and it may be superseded by technological development, and that's not actually in anyone's interest, in the interest of business or those trying to scrutinize business. So they are trying to make it less prescriptive, though also saying that to minimize uncertainty, they will issue interpretative guidance. Again, in a way, it comes back to the balance we were talking about earlier about competition enforcement. The difference, the balance between giving legal certainty to businesses, and that means businesses under scrutiny and businesses who may be wanting to submit complaints, but also being economically realistic and so on. There is a slight difference in approach between the EU and UK on that. We will see how it pans out. But at one level, it is an opportunity for business that it's not too prescriptive, to make sure that the rules are first drawn up and then tailored in such a way that they don't become too hard and fast, too inhibiting of creativity and innovation. And we will see how that works out.
You mentioned few hallmarks of the in passing, by the way, but still they are
Yeah,
there. Pro-competition,
yeah.
so proactive modality, tailoring, something rather counterintuitive for traditional ex-post competition mindset, which is responsive or reactive to an infringement. The infringement is a must. So it's the idea is less about, much less about remedying market failures, being a proactive designer. Your task is more prosecutorial in a sense, yeah. In our how we've been somehow trained.
Mm.
Here we talk about much more discretionary regime. You got a very generous toolbox. There's an opportunity in the UK context even to tailor it in bespoke fashion, and thus the discretion is there. So the question consists of two parts. Is
Well,
it
subject to
doable?
appeals, subject to the proportionality
Yeah.
requirement. Well, I think those are quite important things, because it's not meant to be, and I don't think the CMA sees it as a carte blanche to, charge around randomly. We know why the legislation's been put in place, whether one likes it or not. But legal safeguards have been built in, effective and proportional, and so on, that an appeal mechanism, the countervailing benefits exemption, that are at least designed to ensure that it doesn't curdle into something that could inhibit rather than encouraging innovation. And I think it's incumbent on businesses, their legal advisors, all in this world, including the CMA, to make sure it works as the legislator intended, and doesn't become a sort of discretionary carte blanche.
Do you think it's even possible in principle, assuming that a jurisdiction X grants generous, pretty much unlimited is it even doable as a conceptual endeavor to be such a proactive regulator, mindful of all the intricacies of each specific digital market, and introducing changes without encroaching into the principles of liberal democracy, so to say, but which could improve the markets or tailor markets proactively? Or it would be too ambitious, too megalomaniac, and doomed to fail, so to say, and maybe it's something in between.
So I know there are voices who have strongly made the point you've made. One has to hope not. One has to hope it doesn't produce that, threatening consequence. As you know, the legislation was passed with the support of both parties, both main parties. It was basically it slipped in the last week before the general election, precisely because it had bipartisan support. I don't think anyone intends that. I'm sure the CMA doesn't intend that. And as I say, there are safeguards built in so that we can all keep their feet to the fire. I mean, you talked about sort of designing and so on. I am not sure. Look, there are. I hope, and I don't think anyone has a particular model for how things should play out. I think, you know, as we all know, it is thought that some of these problems can be addressed by changing conduct, others by structural changes on these alleged problems. There's no one size fits all on that. It will depend on the circumstances of the case. And at the risk of repeating this, but it's absolutely central to the legislation, on what in the specific circumstances of this case is likely to be effective and what is likely to be proportionate, that it achieves what it's supposed to achieve, but doesn't overreach and go beyond that. And I think there is, you know, there's clearly plenty of scope for serious discussion and examination and investigation of alleged problems and so on, for all the parties, including the regulator, the CMA, to engage in productive discussion. And I can see it working out like that without any preconceptions about the end result, because the end result, the desirable end result, will be different in according to the circumstances.
Okay, let us now look at the procedural aspects and trying to
Right.
visualize the following, let's say, 2 years.
Yeah.
Not procedural, but factual rather. Do you
Yeah.
think what should we expect? A designation of a handful, maybe 2, 3 years. Some rumors suggest the undertakings with strategic market status, and zooming in within this asymmetric regime, even making it even more asymmetric, or rather designation of dozen or 2 dozens of again undertakings and specific digital activities. Which one is more plausible and which one is more effective?
So I'm not privy to thinking on this, but if you take, you know, standard prioritization principles for the CMA, they will want to go for the biggest, what they see as the biggest problems in the markets. So certain things flow from that about designation of SMS and about what conduct to look for. I would guess that given the expectations from politicians and others, and the business community and others with an interest in all this, they will want not just to be designating, but to be acting. And it is noteworthy, I think, in their draft guidance that they say that you've got, I think, a 9-month period for designation, but in parallel with that, they can start thinking about, if a company is designated as having strategic market status, whether there are problems that need addressing. We also know from the draft guidance that they can have regard to previous work they've done under the Competition Act, under market studies and market investigation. So they're not doing it completely from a clean slate. And I don't know whether people saw in August, so recently, there's been a couple of Competition Act decisions to do with in-app payments by the CMA, relating to Apple and to Google, where cases have been terminated on administrative priority grounds. If you look at the statement that the CMA has put out, they are saying that they're not going to waste that work. If there's SMS designation, they may well use it to scrutinize these practices under the DMCC Act.
You mentioned draft guidance
Yeah,
on DMCCA, and I wonder from your observation again, without being
yeah,
mindful that you have the institutional
yeah,
loyalty and you, you are not expected to tell us too much, but just from the broader when we do public consultation on such important document, you somehow anticipate that you receive avalanche of submissions by different stakeholders. So maybe again, for those of us who never had a chance to walk
yeah,
inside such powerful institution, um,
yeah.
how does the process, what's the power of butterfly effect? Is it like, is everybody expected to process all the submissions, or they're being divided by different people, members of staff, case handlers?
Yeah. Well, first of all, just for everyone's clarity, you say you, but it's no longer me. I'm no longer there. I'm now a, a legal advisor in private practice. Um, Look, the law requires this, and the practice is that consultation is taken seriously, and the practice is that not just because the law requires it, but because if any good public authority wants to get it right and doesn't want to be like a bull in a china shop, wants to make its decisions having regard to serious points that are made by the people it consults, which may be businesses who are likely to be under scrutiny. It might be businesses who are likely to be complainants. It might be consumer organisations. It might be all sorts of other organisations. They are taken very seriously. That's not to say that they are all accepted, because obviously thinking has gone on before any draft document goes out to consultation. But they are taken seriously. They're considered. They're discussed. I would say, and will say to the businesses that I advise, you are more likely to have impact if you make a few strong points quite pithily, rather than a very, very long document where your strong points drown in detail. And if they are important points and you are worried that they won't be understood, there is nothing to stop you trying to make those points orally to the CMA as well as in writing. Now, of course, CMA hasn't got time to see everyone, but very often on important consultations, it will organise round tables, and it also engages with the wider community through things like the City of London Law Society, Competition Law Committee, and equivalent consultation bodies. But the key thing is to be heard, make points that are realistic and practical rather than merely rhetorical. Make your strongest points, make them pithily, and see whether you can have an opportunity to supplement that by conversation, because I think all of that has the most chance of impact. And as I say, it's in everyone's interests, including the CMA, that good points are made and understood.
We understand that the focus on digital markets will continue. So my last question is related to your observation about the specific features of legal profession dealing with competition law and digital markets, but maybe competition law more generally.
Yeah.
Do you see some evolution of the skills and attributes which a successful or appointable university graduate should possess, or it's more pretty much of the same with small
No,
refinements and improvements?
it's not micro. I think I've already said it's changed beyond recognition. I think, we've talked about the contentious element of it, and that's become much bigger. We've talked about the well, the awareness of new trends like labour market, environmental trends, and so on. But I think, I think it will be impossible. It's always been impossible to do this without having some understanding of the sectors that competition authorities pay attention to. I mean, that's part of the interest of being a competition lawyer. You're not just looking at businesses as corporate structures, you're looking at the actual activities, what they do and how they do it in the markets they operate. But I think in the sectors that are most likely to be subject to scrutiny, and that includes the tech sectors, it is well worth investing in time in understanding how they work and so on. Now, that's a challenge, but it's also what I have found, I'm sure you have found, lots of people find, makes competition so interesting, that it isn't static, that you need to understand policy context. You really, really need to understand policy context. You need to understand the real world. And as the real world changes, and is changing rapidly, both legislatively and technologically and economically, you need to keep track of it. But I mean, it makes sure that it's a very fulfilling and not at all a static or boring career.
Absolutely. Michael Grenfell, thank you very much for this very nuanced and informative conversation.
Thank you very much. Thank you.
Great. Okay, so I stop